Well, the Attorney General of Rivers State, Worgu Boms, joins us on this matter. Good morning.
Thank you. Good morning.
Well, what exactly is the state doing about this as it stands? The appointment of a CJ.
The appointment of a CJ in Rivers State? Well, where we are is that there is a federal high court judgment. We took the NJC to court to say that your recommendation of Honorable Justice Daisy Okocha, and indeed the reason you gave for rejecting the first nominee, PNC Agumagum, that the reason is unknown to law. We wrote to them. They stuck to their guns. So we went to the Federal High Court, and the court affirmed our position and voided the recommendation of Justice Okocha. And as far as we are concerned, that matter should have been over, based on which we appointed Justice Agumagum. He went to the assembly, was clear, and we were sworn in. The NJC suspended him, as you know. That's where we are.
So let's go back to the Federal High Court judgment.
Yes.
Clearly, because we were trying to find out from Osahon Ihenyen what that means to this whole equation, which he says, well, there's an appeal from the NJC concerning that judgment.
Yes. The notice of appeal was filed or served on us just few days to the day the NJC wrote to Justice Okocha asking her to begin to assign cases. So just some few weeks ago. At any event, a mere appeal does not in any way operate as a stay of execution of any judgment. So it's neither here nor there.
But Mr. Ihenyen was saying something about when there's an appeal, everything returns to status.
I had him, and I know that with due respect to him, is wrong in law. A mere appeal, I'm talking law, not opinion. A mere appeal does not operate as a stay of execution. There must be an application for stay and granted.
Okay, let's go back to some of the things he talks about, even from the Constitution, about the role of the NJC and that of the governor. He said the governor has no powers to appoint a chief judge.
Who says so? My colleague.
You heard him.
That can be correct. I thought I wasn't hearing him well. There are 4 processes, or let me say 4 institutions, that play critical and equal role in the process of appointment of a chief judge. The State Judicial Service Commission draws up a short list of persons or candidates and sends to the NJC. The NJC from there, they can't go outside the list, now makes a recommendation to the governor. The governor makes the appointment subject to confirmation of the House of Assembly. In fact, the Constitution defines the governor as the appointing authority. Nobody else appoints the chief judge or acting chief judge except the governor. In fact, the letter, if you allow me,
go ahead.
The letter written to the governor by the NJC, signed by the CJ and herself, is contained in this judgment of the court. I think I brought it, yes. And it states, just 1 minute, I think I got it, I have it here. It informed the governor that at their meeting, see what they did, and they have therefore requesting him to appoint Justice Daisy Okocha, subject to confirmation by the Assembly. It's here. So the CJ and herself wrote. So how can he come and say that? So who appoints after the recommendation? It is the governor. You don't need to use in the Constitution section 271 sub 4.
Why all this controversy? Why? Because they say she's also the most senior in hierarchy in the state. So why is the state kicking against her appointment?
First of all, we must understand that no law states that to be a chief judge, you must be a judge. No such law. You need not be a judge first to be a chief judge. Secondly, no law states that you must be the most senior judge in the High Court to be chief judge. No such law. All the law states is 10 years post-call requirement. That being the case, it was wrong of the NJC to reject the first nominee on the ground that he is not the most senior judge. That is the problem. So the NJC was becoming a lawmaker. That is the problem. So we said, no, the reason you've given is unconstitutional. If the law says 10 years post-court is the reason, why are you now adding a requirement that the person must be the most senior judge in the High Court? We said no, and the court agreed with that.
Okay, now put us through what exactly happened in your case in River State. Are you saying that you did not include Mrs. Okocha's name on the list?
We did, 2 persons. First person, Justice Agmagu.
So the State Judicial Commission.
Service Commission, yes.
Yes.
Shortlisted first Justice P.N.C. Agmagu,
Yes.
number 1. This is the person we are recommending. The next most senior judge in the judiciary, Justice Daisy Okocha. They stated that we're not recommending her for so and so reasons.
They stated that they were not recommending
Yes, that the person we are recommending is the first person.
So why did they put her name on the list?
It is for the agency to say, look, 1, 2 more persons, or ask for clarifications, whatever it is. But the point is that they refused the first nominee and chose the second one and then gave a reason unknown to law. That's the point.
No, the point is, if there was a list,
Yes.
we know that these are the possible people that could become the chief judge.
Yes.
Or, that can become the chief judge
Yes.
in River State.
Yes.
And then the State Judicial Service Commission sends this list to
Yes.
the NJC.
Yes.
The NJC has 2 choices.
Yes.
By no design of theirs. It
Yes.
came
Yes.
from
Yes.
River State.
I agree. Yes.
Yes. So
Yes.
if at the end of the day, what it means is that if you don't take this one, you could take this one. I want to believe that's, that's what it means.
If the reason they give for rejecting the first nominee is not known to law, then the basis of their choice becomes legally doubtful. That's the point.
The question will be, do they even have to give any choices?
But they gave a reason. They gave a reason.
What if they just found one more suitable than the other?
They should have
Or
said
if
so.
they said they cast lots for them and
They didn't say so, but
the
they
lots
gave a
fell on
reason.
one of
They
them.
gave a reason. They said the reason is because Justice Agmagu is not the most senior judge in the High Court. So that reason is unknown to law.
So, okay, now, granted, that
Yes.
reason is unknown to law
Yes.
as clarified by a court of law.
Yes, yes.
Now, it's back to you.
Yes.
We say this is the reason we rejected the first one.
Yes.
We've taken the second one. What problems do you have with the second one?
Because if we allow it, we are now allowing NJC to do what the Supreme Court refused INEC from doing. If you remember, Musa read up the law, and found these are the requirements to form a political party. And he complied with them, went to INEC. INEC said no. INEC added more reasons. Musa said, you can't do that. You're not a lawmaker. And went to court. And the court agreed with Musa. So it's a question of law. If you allow it, it means that the NJC has become a lawmaker. Then tomorrow, the requirement of 10-year post-court is no longer enough.
Now, my point is,
Yes.
while you're fighting that battle,
We have fought it and we've won
or
it.
sorting it out,
Yes,
in
we have
the
sorted
court,
it out.
because right now
Yes.
they say that they have appealed that particular decision.
Yes.
While that is being sorted out,
Yes.
what problems do you have with the current CJN in
There's
court?
no- who is CJ?
The chief judge of River State, as recommended by the NJC.
First of all, the NJC never recommended Justice Daisy to be chief judge. That one is already voted by law. So where does that take us to? It's here.
They never recommended her.
That is, the recommendation is voided. As it stands now, that recommendation no longer exists. It's here. Can I read it for you? It's here. It's voided.
Please go ahead.
Okay. The judgment states clearly on page 79 that the first defendant's letter to Daisy of 22nd of July 2013, but received by the plaintiff, the governor, on 30th day of July 2013, wherein the former claimed to be entitled, empowered under the Constitution of the Federal Republic of Nigeria to recommend only the most senior judge of the High Court of River State to the first plaintiff for appointment as CJ of River State, and indeed recommended the most senior judge of the High Court of River State Judiciary, contrary to the advice of the second plaintiff, is wrongful, null and void. It's clear. So we can't talk about it anymore. In fact, this stop there said that the letter afore described and the decision of the defendant, as NJC, at its meeting held on 17th and 18th of July 2013, recommending to the first plaintiff, the governor, for appointment as CJ of the state, the Honorable Justice D.W. Okocha, in preference to Mr. Justice P.C. Agmagu, on the ground that the letter, who was preferred by the second plaintiff, that was the State Judicial Service Commission, in his advice to the first defendant, was not the most senior judge of the High Court of Rivers State is wrongful, not have no effect. In other words, you're recommending this is voided. The grant is voided. What did the court go further to say? It restrained the NJC in these words. It is ordered that the NJC, that's first defendant, acting by itself or through its council members, servants, agents, and privates, are hereby restrained from carrying into effect the decision and recommendation contained in the said letter of 22nd July 2013, or acting upon it in any way or manner detrimental to the interest of the plaintiffs, or acting in a way.
We think that your point has been made. But
fine. Sorry. So you can't be talking about it anymore. There's no recommendation in law. Okay. That's what I'm making, yes.
Okay, but the question then will be, how do you then intend? It would seem that, first of all, you already had a preference for the first candidate.
By the JSC recommendation.
You had.
It is the State Judicial Service Commission that does not the governor.
You had absolutely no influence in that.
How? The law says they are independent and they are free from anybody's influence, unless you have any evidence. But the point is that, okay, the court has said that recommendation is void. Let's take it from there.